Yeah, so let's talk about DUIs because that's something that happens unfortunately a lot.
Right.
And so we have a criminal defense attorney here to help us walk through this. So guy goes out, business dinner, has one too many to drink, gets in the car, gets pulled over. Next thing you know, they're taken in for DUI, and all of a sudden the triggers are, or the buy-sell agreement is triggered, and now he's got all kinds of problems. But I want to go back to what happened between the time they left the restaurant and how this happened. So, typical case, we hear this all the time, don't blow, do not give blood. And then in Houston here, we have, what's it called? Mandatory or no
refusal.
No refusal. So, walk us through what happens in a case where leaves the bar or leaves the restaurant, gets pulled over.
Absolutely. Thanks, Alvo. Thanks for having me. So, in Texas, it's actually DWI. There's also DUI, but that is a charge for those who are under 21, and it's a Class C misdemeanor with any detectable amount of alcohol. So I just want to distinguish to our listeners the difference between what is a DUI and a DWI. So in what's commonly referred in other states as DUI, it's DWI here in Texas, and it's driving while intoxicated. That's what it stands for. And so there are, let's see, so someone has some drinks and they get into the car and they get pulled over. What happens, right? Number one is don't drink and drive. But the problem is it's not illegal to drink and drive. See, you and I, we can go to Lupe Tortilla tonight and we can have a margarita or two and get in our car and drive home. That's because the legal limit is 0.08 here in Texas and pretty much across the U.S. anywhere. And it would make my job a lot easier if there was zero tolerance for alcohol, because if they had alcohol in them, boom, that's it. They're done. They're guilty. But that's not the law. The law is that you cannot be intoxicated while operating a motor vehicle in a public place. Now, there are three different ways a prosecutor can prove intoxication. One is not having the normal use of your mental faculties. The second way is not having the normal use of your physical faculties. And number three would be to prove that you had a blood alcohol concentration of a 0.08 or greater. So that's where the 0.08 comes in. So with an officer or someone who's never seen you before, how do they know what your normal mental faculties are like? How do they know what your normal physical faculties are like? So typically prosecutors rely on that number, the 0.08 or greater, whether it's breath or blood, in order to produce the conviction in a DWI case here in Texas.
So when they have these no refusal weekends, what is that all about?
Sure. So no refusal. So just to be clear, it's no refusal in Harris County 24/7, 365. And so what that is you have a constitutional right to refuse any and all field sobriety tests, as well as any and all blood alcohol tests, that being the breathalyzer, the intoxilizer, or having them draw your blood in order to determine what your blood alcohol level is. And so in Harris County, Texas, they have a judge or magistrate that is on standby at all hours of the day, at all hours of the night, ready to read a search warrant affidavit and sign it, which then becomes the search warrant. And then they get to draw your blood if you refuse to blow. You brought up a question of do not blow. And so there are two schools of thought about that. And I want to talk about both. One is do not blow. And like I said, in Harris County, it's no refusal all the time, which means if you don't blow, they're going to get a search warrant and draw your blood 99.5% of the time. It's very, very rare in Harris County that they don't have either your breath or your blood. The other school of thought is blow, don't bleed. That's another school of thought. And the reasoning for that is it's a lot easier, or juries tend to believe that machines are faulty and they're a lot more faulty, and you can beat those breath tests easier than the blood because they just assume that the blood is the gold standard. In either way, if a good criminal defense lawyer hires an expert, they'll be able to point out some inaccuracies or things that weren't done properly procedurally. and there might be something to go with. The best thing, though, my advice is, if you're ever pulled over on suspicion of DWI, be polite to the officer, refuse any and all tests because you can, and then hire a good lawyer. That would be my advice for anyone under suspicion.
Yeah. So thanks for that clarification. I want to pull this back in now that we know how this works to the actual impact that it has on a business and a business owner. So let's say they do all the right things, they get the right attorney, and ultimately may end up even winning the case. But there is a toll there, isn't there? There is the financial cost, the reputational risk, Jack. There's all kinds of things. And you brought up some of the buy-sell agreements have probably clauses in there that says, hey, if you bring bad publicity on us, that might trigger the clause as well. Armen, talk to us about just the costs, not, from time, from money, just trying to go through this and somebody defending themselves against a DUI charge.
Sure. It's costly. I can tell you that. So from the minute you get pulled over, if the officer is asking you to step out of the vehicle, they've pretty much made up their minds that they're going to take you to jail that night. If there is not someone else in the vehicle who is sober and can drive home, your car is getting towed that night. So it starts right there. To get your car out of impound, you're going to be paying hundreds and hundreds of dollars, and depends on how long it sits there in the impound. Next, you get booked into jail. And if it's a busy Friday or Saturday night, booking, processing could take a long time. So you're sitting there waiting hours and hours to get processed in, and then waiting hours and hours to get processed out. So that's cost, that's opportunity time that's lost there. Generally, on a DWI first here in Houston, they will give you a PR bond. So what a PR bond is, they let you out on your own recognizance on the promise that you'll return back to court to all your future court settings. That's great. That's changed a lot. Back in the day, it used to be pretty standard, $500 to $1,000 for the bail amount. And so that was another cost you used to have to pay, is get a bondsman to make the bail, and in order for you to bail out of jail. So then once you're out and you go to your first court appearance, of course, you always want to be represented anytime you go to court. But if you don't have a lawyer on the first setting, it's not the end of the world. In fact, I would advise listeners to not rush and hire the cheapest lawyer just so they're represented on the first case. If you don't have the funds to hire a good lawyer, go to court, tell them you need more time, and they will give you more time to hire a lawyer. And if you can't afford one, ask for a court-appointed lawyer. Some are great and some are not so good. But if you don't have the money, then that's your only option. If you do have funds, I would say that a good lawyer in Houston, Harris County, Texas, will cost you about $10,000 on a first DWI. That's starting. Right. I know some lawyers who charge $30,000 for a first-time DWI, and that doesn't even include their trial fee in the event it has to go to trial. So the range is very great, but most good lawyers will charge at least $10,000 for a DWI first, and that's with no accident, no criminal history. That's kind of what you're looking at, Avo.
Yeah, and so those are just the costs just to go through that process, not to mention, if there's an accident, now you got additional liability. Potentially your spouse is now upset with you. Your company's upset with you. Right. So bottom line here is just don't drink and drive, right?
Right. If you can take an Uber, take an Uber. I mean, I'm not against DWI laws. A lot of people think that because I'm a criminal defense lawyer, I'm against the laws. Quite the opposite. The laws are good. They're here to protect me and you. We're driving on those same roads, right?
Right.
And so, of course, I will defend anybody at any time. But ultimately, if you can avoid drinking and driving, do so. But again, it's not illegal to. It's illegal if you are intoxicated. So all those signs on 610 and I-10 that say drink, drive, go to jail, that is not the law.
Yeah, it just doesn't make sense to me. You got a successful business owner that's got a nice business going. Why would you risk this? Not only are you risking your business, potentially your partnership, both domestic partnership and business partnership, and heaven forbid you cause damage and hurt another human being. So just something to just stay away from if you can.
If you can.
Yeah. And so speaking of avoiding things that you can, another area where business owners run into trouble with the criminal law is one that, last couple of years has been in the news, is when COVID hit and we had the government program, the Paycheck Protection Program, PPP. And we keep hearing a lot about how people took these loans and they used it for personal issues rather than for business purposes. And now the government's starting to crack down. Right. And so what have you seen in that realm with how's the government coming? What are they doing coming after those people that misused their PPP, or they flat out lied and took money for PPP when they shouldn't have?
Sure. So, what I've been seeing is the government is cracking down, both state and federal, and we'll kind of talk about the difference in a little bit as to state and federal charges. In Texas, it doesn't matter if it's a theft or an embezzlement or larceny. It's all considered theft. Okay. And so in Texas, if you took funds if you misappropriated funds by lying on an application, a PPP application, they're coming after you, either in state court or in federal court. If it's in state court, they're going to hit you with a theft charge, because that's all the crime that it is in Texas. And really, it depends on the amount, is what level of crime it is. So in theft cases, generally, if it's over $2,500, then it's a state jail felony. That's kind of where the felonies start. Anything less than $2,500 is a misdemeanor. So $2,500 to $30,000 is a state jail felony. $30,000 and up becomes third degree, second degree, first degree. Anything over $300,000 is a first degree felony. You're looking at 5 to 99 or life in prison if convicted. So it can add up real quick. And so, what I'm seeing is they're cracking down big time. They're going back, they're reviewing the records. So I hope you didn't do it. And if you did, my advice is hire a good lawyer and have a lawyer on retainer in the event that charges are filed, or as soon as you feel that you're the target of an investigation, go and talk to a lawyer. The best advice I can give listeners all day long is never, ever, ever, ever talk to law enforcement. Don't talk to them, because what you say is evidence. They will use that against you in a court later on. But if your lawyer says it on your behalf, that's not evidence. So you want to cut yourself off from that criminal liability by hiring a lawyer and having them be your mouth, your eyes, your ears, and conveying whatever it is you want to convey to them. Maybe you've already paid a lot of the money back. Maybe you've paid all of it back. Maybe you have the money to give back. Whatever it may be, let the lawyer negotiate on your behalf. Don't think you're going to talk your way out of it. You're only going to dig yourself in a hole. So if you find yourself in that situation, go find a lawyer, hire a lawyer, let them do the talking.
So let's talk about that for a second. So business owner maybe does a second look and they say, maybe this wasn't right. And they go to in-house counsel and they start talking about things. Now, correct me if I'm wrong, but in a situation like that, that in-house counsel is not representing that business owner, are they?
Correct. So in the case of an in-house counsel, what you have to be clear is that lawyer who works for the company or the corporation represents the company or the corporation, not any of the owners, not any of the managers, not any of the directors. And so sometimes business people who have their own business or have their own corporation will go to the in-house counsel and will seek advice. And that is not necessarily attorney-client privilege because, again, the lawyer represents the corporation, the entity, and not any of the individuals, even if it's one person who owns all of it. You got to be very, very clear. So I would advise, and the lawyer who is in-house counsel should advise them that, hey, whatever you tell me, by the way, it's not privileged under attorney-client privilege. And so you want to seek out your own lawyer in this case. So just be careful out there. If you do work for a big company or corporation, and if you have any sort of title, just know that by going to the in-house lawyer, you might not be covered by attorney-client privilege.
Yeah. Speaking of attorney-client privilege, the other area that I was reading about, and maybe you could elaborate on this, is when somebody gets subpoenaed who's got custody of records, how those records, you can't refuse to turn those over, and confidentiality goes out the door, or self-incrimination, something along those lines I was reading. What's the latest on that front?
Sure. So generally, if you get subpoenaed and you have a right to invoke your Fifth Amendment and not produce documents and not testify against yourself. So if you're being subpoenaed to go before a grand jury and to either for your testimony or to produce documents, you have the absolute right to invoke your Fifth Amendment privilege, which even innocent people do, believe it or not, and not produce or turn over those documents or give that testimony. However, the caveat is, if you are, let's say, a custodian of records or someone who is working for one of these corporations, and the records that they're asking for might incriminate you in a crime, you cannot then invoke your Fifth Amendment privilege because as in that capacity, as a custodian of records, you have to turn over those records, even if those records may incriminate you of a crime in your employment capacity. So very, very careful. Of course, always consult with a lawyer to know what your rights are and what you can and can't do. But just know that you can't just, Fifth Amendment is limited to you personally, but not as your role or your capacity as a custodian of records.
So last time Lincoln was here, we talked about issues where an owner discovers some kind of employee fraud or something that might be criminal in nature. And we were talking about, okay, do you automatically go to the cops? Do you take care of it internally? Do you give them an opportunity to fix this? Actually, it was with our forensic accountant that had was talking about that.
A little about that too.
So what happens? A business owner is going through their records, they're doing oversight, and lo and behold, they come across where an employee has done something potentially criminal, right? Where it might impact the business. So for example, an owner has delegated the PPP loan application to an employee because they're busy running the company, and the employee does things that maybe they shouldn't have because they're trying to get money, but they should have never qualified for that money, and the business owner finds out. What should they do at that point? Do they do they just say, "Hey, we got a problem here," and go fess up? They get an attorney. I mean, you got employment law here, you got criminal law. I mean, what happens in that case where our business owner listening in on this says, "You know what? I trusted my employee with this, and now I'm finding out they did things that they should not have. Help." What should they do?
Sure. So my advice is go talk to a lawyer, right? A lot of lawyers, criminal defense lawyers especially, we don't charge for consultations. If there is a need for representation, then we'll tell you and we'll advise you, and we can go from there. But generally, you have to have, in order to have a crime, you have to have two things. You have to have mens rea and actus reus. This is criminal law 101. This is first day of law school at any law school teaching criminal law. So the mens rea is the mental state. You have to have some sort of mental capacity, an intention, intentionally, knowingly, recklessly, with criminal negligence. There has to be some sort of intent, unless it's a strict liability crime. So strict liability crime would be, for example, statutory rape, right? So it doesn't matter. It just the fact that if a girl is under 18 years old or under 17 years old here in Texas, they're not considered an adult. So even if there was consensual sexual relations, then no good, because you violated the law. So that would be that'd be different. But here you need a mens rea and you need an actus reus. So the mens rea is the mental culpable state, and then the actus reus would be the act of doing something. So if your employee does something, chances are you wouldn't be necessarily criminally liable unless you knew that this person had some sort of background and you gave them authority to do something. So it can get sticky, and law of parties in Texas here is very favorable for the government. So in other words, if they say you're a co-defendant, you're just as culpable as the person who did the act, even though you may not have done the act. So it's very tricky. Also, on the federal side, we have conspiracy, and conspiracy is just two or more people agreeing to do something, and the agreement itself is the crime. So the other person doesn't even have to act out the criminal act, but if two people agree to do something illegal, that you can get prosecuted for that. So
we're talking about PPP, we're talking about a federal program, and then we're talking about state of Texas. Let's talk a little bit about how the two venues differ, right? When Lincoln was here, we were talking about civil litigation, commercial litigation. We were talking about how the different venues might impact a litigant, and how, shopping for the right venue makes a difference. Here, if the feds come after you, right, it's completely different than when the district attorney or the state comes after you.
Absolutely.
Talk to us a little bit about the differences between state charges versus federal charges and what those processes look like.
Sure. So I handle both state and federal cases. Generally, state cases are your kind of everyday, more regular crimes, your DWIs, your assaults, your sex assaults, your evadings, your thefts, small thefts, generally, that kind of stuff. But of course, they do prosecute. The state can also prosecute white collar crimes, and they do. And Harris County has a consumer fraud division and has a cyber crimes division. They have all sorts of financial crimes divisions. And so they definitely go after white collar crimes. So typically the big difference is, by the time the feds have charged you, they have boatloads and boatloads and boatloads of evidence before they charge you. And so by the time the indictment comes down, they have all of their evidence wrapped up in a bow, ready to give to the defense lawyer. And that case is going to be set for trial in 70 days. That's the Speedy Trial Act of the Federal Speedy Trial Act. So it's very quick, unless it's a complex case which the judge declares a complex case. Then there will be more time afforded to the defense in order to review all the evidence and come up with a defense and all that. Now, in a state case, it's quite the opposite. In a state case, they'll charge you first, and then the investigators or the police department will go out and gather the evidence they need in order to convict you, right? Sometimes they do have a good amount of evidence, but all they really need is probable cause to make the arrest, which is somewhere less than 50%. And so they'll charge you, and then the DA will then tell their investigators to go out and collect whatever evidence is out there. And then it first gets turned over to the prosecutor, and then the prosecutor turns it over to the defense. So, and this process could take, on any given felony, at least a year, if not 2 years. I'm set for a trial in 2 weeks where it's a felony case, and it's been pending for 4 years. So Harvey and COVID definitely slowed some things down. Things are starting to pick back up, but big difference between feds. They go to trial real quick. They have all the evidence ready to go. State, you're waiting for months and months and months, if not years, to get everything you need and before you get a trial.
Yeah. So Jack, bringing this back to our hypothetical buy-sell agreement where there's clauses like this. I mean, now that we know things like this could drag on and the technicalities of the accusations, the convictions, I mean, how much attention do business owners need to pay to what they're putting into these buy-sell agreements as far as, what did you call those clauses? The moral...
moral turpitude.
Yeah.
So, I mean, to answer your question, very closely, I mean, the language in that agreement is really going to dictate how much leverage you have or how much or you don't have in a certain situation. So it could be you're very clear and say you have to be guilty of a crime. Well, that's a lot different than being accused of one. And as Armen explained, like it could be years that you're accused of one and not convicted guilty of it. And so depending on which side for representing the employee or the employer, we're drafting these things in a certain way where we're trying to give the party we're representing the most leverage. So if I'm the employer, or on one side of the buy-sell agreement, might want to say, well, all you have to do is be accused or arrested, and we're very clear that you're in default. And now I hold the cards to make a decision on what I want to do. On the other side, you might say, well, I don't want to be accused of something and all of a sudden, lose my whole deal that I put together. You want to be convicted of it. You understand the situation that if I get accused of fraud or theft or embezzlement, that maybe I shouldn't be a part of the company, but it's easy to get accused, as Armen explained. So you might want to be clear and say, look, I have to be convicted guilty of this in order for it to be a violation of the agreement.
Yeah, and when you said employer, you're talking about the former owner who sells the business and now they're an employee.
Yeah. It's situations where you're the seller and now you're going to become an employee. And so now you're entering into an employment agreement, or similar provisions around buy sales where you might have a co-owner and you want to build in protections to protect yourself and vice versa. And how specific you are can make or break a situation.
Yeah, which, goes back to, we've talked about this all the time. A business partnership is nothing more than a divorce waiting to happen, right?
Right.
Eventually, voluntarily or involuntarily, every business comes to an end, right? And you want that orderly transition. And so when you're talking about these types of clauses in there, it goes back to the judgment of who are you bringing on as a partner, right? If they're showing you signs ahead of time that maybe they lack some of the judgment, but they're good for your business because maybe they're good in sales or whatever, it's going to come back and bite you, right? So having these clauses in there is further, I guess, reassurances that you could get rid of them in case it rears its ugly head. But I think prevention is better. Just don't get involved with folks like this to begin with. So you were talking about evidence that the feds have when they come and indict somebody. And so cases we hear about is business owner is going through their records and they find something. They're like, maybe it's better if these records don't exist. And they start deleting things and getting rid of things. Very dangerous, right? I mean, it was in the news the other day.
Very dangerous.
This big civil case that's happening in, let's just say, in the state of Delaware that everybody knows about. The judge came down the other day, very harsh on one of the parties, saying, you're not turning over records. They were able to get records from third parties that should have been turned over by first parties because they were on it. Right. And so the judge didn't look very favorably on it. And that's in a civil matter. In a criminal case where somebody goes and gets rid of evidence, that's an entirely new crime, isn't it?
It is. So never delete anything. You want to consult with a lawyer and talk with a lawyer who's had experience in dealing with these matters before. But you don't want to delete anything because that, like you mentioned, Avo, could be a completely separate crime of tampering with evidence. And in Texas, tampering with evidence is a third-degree felony. You're looking at 2 to 10 years in prison just on that charge. In addition to whatever else the government might be charging you, whether it's the state or federal government. So you definitely don't want to tamper. You definitely don't want to delete anything. You just want to go talk to a lawyer. And in criminal defense cases, let me be clear about this. In criminal defense cases, the accused has zero duty to turn anything over to the prosecution. Okay, I want to say that again. In criminal defense cases, we have zero duty as the accused to turn anything over to the state. The state, the government has to turn everything over to us, and we don't owe them anything. In Texas, it is trial by ambush in the criminal realm. We give them nothing, and they have to give us everything. That's how it works. And so if something bad is out there and it exists, it doesn't mean it necessarily gets turned over, right? But destroying that could bring a crime on its own. So be very, very careful.
Right, because they're going to find it. They could find it.
They could. Depending on, I mean, we can talk for hours and hours about what that evidence is and how they could go about finding it. But generally speaking, right, they have to give you the evidence that they're accusing you of. They have they have to give everything. So you know exactly what it is you're being accused of. And it's not, the old saying, it's not whether you're guilty or not, it's what they can prove at the end of the day. And so they need to have proof beyond a reasonable doubt.
Yeah. So something I was reading the other day, and I want to ask your opinion on this. They were talking about when, a company, an entity could be charged for crimes, not just an individual, business owner or an executive, but the actual company if they're doing something. But obviously they need to have an agent that's allowing for this to happen.
Right.
But how does that work where a company could be charged? And if a company is charged, then how does that relate to the executives? Could they, by default be charged as well for the same crime? Or is it two separate things?
It depends is the answer on that. So recently, it was about a year ago, I heard that DA in Texas in a smaller county indicted Netflix for this film with young girls that was in there. And they indicted Netflix, and that there's an incident of the state or the government charging a company for what they're doing. Now, of course, the company has representatives, and someone has to answer. Netflix can't go to prison, right? But but people can. They can put people in prison, and so there could be, like I said, law of parties, co-defendants, and people in charge of making those decisions. They can also be charged. But yes, you're right. Companies, corporations can be criminally charged, and generally it's the executives that are the ones making the decisions who could also have criminal liability that gets attached to them.
So what's the sentencing phase for that? Like, is it just monetary punishment, or can they shut down the business? What's the extent?
It could be any of that. It just depends on what the crime is and how serious it is. And the government, governments can order things to shut down if they're perpetually committing crimes. So
I kind of want to, go back to kind of a more kind of practical thing we've been talking about, which is we're concerned that we have some criminal liability exposure. May or may not be, your advice, and, we can't echo enough, is go talk to an attorney. But for a lot of business owners who, never committed a crime except maybe speeding, it's intimidating to think, I have to talk to an attorney. I'm a good person. I didn't mean to do anything wrong. Maybe I don't want to make it complicated, and I want to keep it to myself. So if I'm one of these persons who's on the fence, what comfort can you bring me to say that I'm making the right decision, going to you, and what can I tell you and not tell you, or what should I be telling you, and how am I protected, knowing that I'm going to be protected from having that information get out there, when in a lot of ways me just not telling anybody seems like me, I'm protected.
Yeah, great question, Jack. So this is what I'm going to tell you is, as I mentioned before, a lot of criminal defense lawyers don't charge anything for a consultation, and whether or not you pay that lawyer any amount of money, that conversation is protected under attorney-client privilege. So even if you don't give, a lot of times you'll be watching something on TV, Netflix, AMC, and you'll see someone in the show give someone $5 and say, "You're my lawyer now." You don't have to do that. Okay. There has to, you don't need any exchange of money for any sum in order for a lawyer that you're talking to, in order for that attorney-client privilege to attach. And attorney-client privilege is very, very serious. Lawyers can get disbarred for violating that. They typically won't. It lasts even after death of the client. So unless we have the client's permission to disclose something that we learned from that conversation, from the attorney-client privilege, we cannot disclose that. And good lawyers know this, and they will take this with them to the grave. So just know that talking to a lawyer does not expose you to any more criminal liability, right? Mm-hmm. And quite the opposite. They will likely give you some free advice. If they care, they will likely give you some free advice where you might be protected. And then they might quote you a fee for pre-charge or investigative representation, where they become your eyes, ears, your mouth while talking to law enforcement. So that way, nothing they say can ever be used against you, because that's not evidence. But anything you say would be evidence. So you really have nothing to lose by talking to a lawyer. Maybe they'll charge you a little bit of money to represent you. Probably money well spent. That's what I would say. A lot of lawyers will represent pre-charge all the way up to the first court appearance. And then if you want to hire them again for the charge representation, I'm sure, of course, they'd be happy to represent you there. But there is a lot of knowledge that we can offer and a lot of protection that lawyers can offer. Yeah, of course, I'm a lawyer. I'm promoting myself, but I've just seen too many people time and time again try and talk their way out of something, and they've ended up in so much more trouble by doing so, or just not saying anything, or not knowing what to do, when to turn it over, when not to. And that really gets you in trouble. So spend a little bit of time, spend a little bit of money, hire someone competent who's done this before, and let them take care of it for you. It's just, you're taking all the problems off of you and giving it to them. And like I said, that attorney-client privilege is powerful stuff. So don't be afraid to openly and honestly talk to your lawyer about what's going on, because it's in their best interest to zealously advocate on your behalf, right? So they cannot turn those things over that they learn through that attorney-client privilege unless they have your permission.
And so let me give you an example that I think can relate to a lot of our listeners, which is, I have a partner, and I start realizing the partner is doing some things that could create criminal liability. Maybe it's stealing funds. Maybe I just come across it, but I realize that the fire they started is going to come and start, hurting me or incriminate me. So I give you a call and I tell you what's going on. What types of things can a criminal lawyer do to help make sure that I stay protected and don't get kind of pulled into something that I really had no idea was going on.
And let me add to that, because the oftentimes the situation is where these partners are often related, especially in family businesses, right?
Right.
Maybe
That's a good
they're
point.
cousins, brothers, sisters, aunts, mothers, daughters. There's some kind of a relationship there. And so they're kind of in this pickle. On one hand, they want to protect themselves and their immediate family. On the other hand, they're blood relatives, and they don't want to mess that up. And next thing you know, they turn a blind eye, and it gets bigger. What's that old saying, where there's smoke, there's fire? Yeah. And by the time it's uncovered, now they're a party to this,
right?
Albeit unwillingly, but because they didn't step up.
Well, see, turning a blind eye is different. You can't turn a blind eye, right? And it's like if you come up to me and hand me a package and say, "Hey, go deliver this to Dallas, Texas," and I don't bother asking what's in the package, that's turning a blind eye. And if I get pulled over and then the police discover drugs or anything else illegal in that package, I'm going to be held criminally responsible for it, even though I don't know what is in the package, right? Because I turned a blind eye. Willful blindness is not a defense. Okay. Yeah. I want to be very clear about that. Willful blindness is not a defense. If you see something that's going on, obviously you don't have a duty to call the police or do anything, especially in a family matter. You probably don't want to do that because you care about the person. But talk to a lawyer and tell them what's going on and have them advise, because it's so fact specific, right? I can't just give advice where it covers everyone at all times for all situations. Right. It's very fact specific. So the best thing to do is stop any sort of potential criminal activity, right? And if it doesn't, then you need to talk to a lawyer and figure out what the best course of action is to shield yourself from any sort of criminal liability. But like we said, we have no duty to turn anything over to the law enforcement, police, prosecutors, unless, of course, they subpoena you in a manner where you're the custodian of records, We already touched on that, but you have no duty to give them anything. So don't, you love the person that you're probably in business with, whether romantically, family, even if it's just friends, you know, you build a love and a trust for each other. You have no duty to throw them under the bus, right? So don't. Just everyone hires their own lawyers, and you'll get justice in the end. And I just very quickly want to touch on that is you never want one lawyer representing two parties or more, right? Everyone should have their own lawyer because everyone's best interest is different than the other person's.
Right.
I would hate to throw one of my clients under the bus to save another client. That's so unethical. And I wouldn't be able to sleep at night. A lot of lawyers do represent multiple parties. It's not illegal to, so long as you have the consent of both parties and you want to document that in written form that, hey, we know that there's a concurrent conflict of interest and we waive that. We want this lawyer representing both parties. I will tell you that me as a person, I would never, ever represent two parties at the same time because of their best interests being different. It's just so much easier. Everyone gets their own lawyer and everyone fights their best interests, and then you'll get justice at the end.
Yeah, I want to ask you, in a situation where, let's say, someone's on the board of directors, multiple people, not just owners, but you have multiple people, and one of the person on the board of directors says, you know, I kind of don't like what we're agreeing to. You know, these four people, let's say there's 5 people on the board, four of them are in favor. I'm not in favor, and I kind of want to step out. But I want to do it in such a way that I want to protect myself. I want to let it be known that, hey, I disagree with this and I'm withdrawing and I don't want to be on this, you know, I don't want the liability anymore. And they're afraid because there might be some kind of, you know, they fear some kind of criminal enterprise happening of some sort. Again, are the steps the same? Should they just go to an attorney on their own, not the corporate attorney again?
Correct.
And say, hey, how should I unwind? Because like you said, it's all case specific.
Correct. That's exactly right. Is go consult with a lawyer. If you have to pay a little bit of money, pay a little bit of money, whatever it is, get good advice so that way you're covered and you're protected. You know, in a board of directors situation, yeah, it's you might, but Jack can talk about the business judgment rule a little bit more. That's kind of how corporations and directors are protected. I'll let him talk about that stuff. That's kind of more civil. But yeah, if you feel uncomfortable about something, go figure out, go talk to someone, figure out what the laws are, figure out what can and can't be done. And you're the boss, and then make the best educated decision at that point.
Yeah. And so the takeaway for me here is, as a business owner, you don't necessarily want to find yourself the first time talking to a lawyer is when you're in trouble.
Correct.
Go to the lawyers, and we've talked about this, Jack, on the transactional side, is go talk to a lawyer before there's a problem. If you think there's a hint of a problem, consult, understand what the process looks like, what your rights are, what the problem is, and so make good decisions based on that. It is going to cost money, but you rather pay a little now than a lot later. Because
convictions are forever. Convictions are for life. You can't undo a conviction. I mean, unless you get a governor's pardon for a state case or a presidential pardon in a federal case, there is no undoing a conviction. And it's Texas has now allowed some convictions to be non-disclosed. Those are in very rare and small situations, but typically, if you're convicted of a crime, that's like having a mark on you forever. Right?
Yeah, and this is a very heavy topic, Jack. I'm kind of glad we have more fun things to do, which is clients are usually happy when they sell a business and they collect their money. But this is a very deep and heavy topic, and thanks for coming on board and sharing your insight with us.
Yeah, and sorry to interrupt there, but one point also about seeking out counsel is, and over the past several episodes there are specialists that cover certain topics. We have Armen here to cover criminal law, and I've covered certain transactions, and we've had a finance lawyer. It can take time to find the right lawyer for you from a personality standpoint, from a specialty standpoint. But you're going to be in a better position if you're proactive and start finding that right person before all of a sudden you're back on your heels and you need someone right away and all of a sudden you're just settling for wherever you can get because, they think that they can help you. You want to be in a position where you have the time and patience to find the right lawyer for your situation.
And I want to piggyback off what Jack just said, is that there's no one best lawyer for everyone. There are certain lawyers that are better in certain situations,
Right.
and you need to find the lawyer that you feel comfortable with. That's really what it comes down to, a lawyer who cares and a lawyer you feel comfortable with, because your freedom is very personal and you want that person stepping up to bat for you, and that person is going to go to bat for you. And so no one lawyer, even a criminal lawyer, no one lawyer is good for every single case. Every case is different,
Right.
and you just have to talk and figure out, do I feel comfortable with having this person represent me? And what have they done? And you can figure that out during the consultation phase.
Yeah, if you ask most successful professionals, most successful business owners, there's a common thread running, and all of them have good advisors surrounding them. And when I'm talking about advisors, not just talking about financial advisors, but just people in general, whether are attorneys, business associates, just folks that give them advice on general things, business related, life related, and they're not afraid to step outside of their comfort zone and just people they know, right? And so the bigger the network, the more access you have to competent advisors and professionals, makes life a lot easier for those business owners.
Yeah.
Information contained in this podcast and accompanying video have been derived from sources believed to be reliable. This content is not guaranteed as to its accuracy and does not purport to be a complete analysis of the topics discussed. Analysis is based on assumptions that may not come to pass. None of the content should be construed as legal or investment advice. You should consult with a qualified professional before implementing any strategies discussed. All expressions of opinion reflect the judgment of the speakers on the date the video was recorded and are subject to change.